This Honorable Court of Tennessee is now in session.
Thank you. This is the March term of the Court of Criminal Appeals in Tennessee and for the Western section. On the panel today, to my right, Judge Tim Easter from Williamson County. To my left, Judge Ross Dyer from Shelby County. I am Kerwood Witt, and I'm from Monroe County. Call our case, please.
State of Tennessee versus Justin Jenkins.
Okay, thank you. Argument of 20 minutes aside. If the appellant wishes to reserve a portion of that 20 minutes for rebuttal, please inform the court at the beginning of your argument. So, Ms. Wingirter, you may begin.
Thank you, Your Honor. Good afternoon, and may it please the court. Brennan Wingirter with the Appellate Division of the Public Defenders Conference here for Mr. Justin Jenkins. And Judge Witt, I'd like to reserve 3 minutes for rebuttal, please.
All right.
Thank you, Your Honor. Your Honors, this case is about sentencing and restitution, and specifically what a trial court has to put on the record when imposing consecutive sentences, a lengthy term of confinement in prison, and also restitution. In this case, there were actually 7 different docket numbers, and each docket number had multiple counts within them. There's a total of 19 counts to which Mr. Jenkins pled guilty. What the trial court did was sentence Mr. Jenkins to the maximum end of his range in nearly all of those counts. Then each count within each case was run concurrent, but then 6 of the 7 cases were all run consecutive to each other. So the very minimum that the court could have imposed was a 3-year sentence. That was the bottom of the range for the 1 Class C felony conviction. Everything else, all the other offenses were D and E felonies and A and B misdemeanors. So the minimum was 3 years, but by stacking all 6 cases consecutively, trial court ended up with a total 16-year sentence for these crimes. The court then ran that 16-year sentence consecutive to a prior 5-year sentence out of Rutherford County, and then on top of that imposed nearly $10,000 in restitution. We are asking this court to reverse those judgments because there is nothing in the record to indicate that this total aggregate sentence was justly deserved for these offenses and was the least severe measure necessary to punish Mr. Jenkins for these primarily property-related crimes. Mr. Jenkins was 18 and 19 years old when he committed the string of theft and auto burglaries that led to these charges. He had been largely in and out of foster care and the juvenile detention center when he was younger, but he had never before been to prison until these were his first adult offenses in Rutherford County, and then similar offenses committed in these Madison County cases.
He was on probation out of Rutherford County when he committed these offenses. Is that not correct?
That's correct, Your Honor.
Okay.
And that
community corrections, wasn't he?
So he was actually on community corrections. That is correct. He was sentenced to a suspended sentence. He was actually eligible and given judicial diversion and then subject to community corrections. And that's a good point, Judge Easter, because I think that because it was a community correction sentence, although it was a 5-year sentence, if he's revoked in Rutherford County, he actually could be resentenced. And that could actually end up being an even longer sentence, again, consecutive to the 16 years here in Madison County. So, yes.
But to that point, though, and you make this point in your brief, and you're not the only person that does it, but I'm gonna give you a hard time about it because you're of me. The trial court here did not sentence your client to 21 years. The trial court sentenced your client to 16 and so, this is just me. It's become one of my pet peeves as of late. I think it's a bit disingenuous to try to make your argument that he sentenced him to 21 years. Your client had already received those 5 years. He had already been punished for those 5 years, or was being punished for those 5 years. And in this case, he was on community corrections, which more likely than not, in almost any other jurisdiction, any other trial court, that trial court's going to say your new stuff is consecutive to your old stuff because you've shown that you can't behave while out on release. I'm not saying it's always, but so, do you really think that we should consider the fact that he can be re-sentenced in Rutherford County, or the fact that this is consecutive to Rutherford County? Because really, what we're looking at is, what was he sentenced for the crimes he committed in this case? Do you agree or disagree with that?
No, I completely agree with you, Your Honors. The point that we're making with the running these counts, the Madison County cases, all consecutive, then on top of that consecutive to the Rutherford County, is simply to indicate that the trial court here did not take into account the total aggregate sentence that it was imposing. And that's just one factor that goes to how this court should review the record. And we're not asking the court to, certainly not asking the court to consider anything about that Rutherford County sentence. That's not an issue here today. But it does speak to the trial court in this case, not imposing a sentence in line with the purposes and principles of sentencing. And I don't mean to, I hope in my brief I did not mislead the court in any way. I certainly did not intend to do that.
But you didn't mislead me. I knew exactly what you're saying.
Right. And I think even the 16-year sentence, right, just focusing on that in these cases is an abuse of discretion. And I want to be clear, because Your Honor pointed out that he was on probation. I want to be clear. We're not arguing that that Mr. Jenkins was not eligible for some form of consecutive sentencing. We acknowledged he was on community corrections supervision at the time these offenses were committed. The trial court found that he had an extensive criminal history. But those are just the statutory bases for a defendant becoming eligible for consecutive sentencing. Even since Bies and Pollard, this court has repeatedly said that in addition to those factors, the trial court has to find that the total aggregate sentence is, one, justly deserved for the crimes, and two, the least severe measure necessary to punish the defendant. Just
for my clarification, and I promise I'm gonna let you argue. I only was talking about as far as the probation, the fact that he was out and consecutive. More likely than not, those two county offenses, one from each county, is going to be run consecutive by the second judge to the first offense. Does that make sense? What I'm saying? I'm not talking about the 16 years. I'm talking about the two sentences. More likely than not, whatever judge sentences him second is going to run it consecutive to what he was on probation for. Does that make sense? What the distinction I'm making?
Yes, Your Honor.
Which is why I was like, the 21 years is disingenuous to me. But go ahead. I'm sorry.
Yes, Your Honor. I understand. No, that's fine. So in this case, focusing on those 16 years, we have not just the 16 years, but also the restitution. So I want to be clear, we're arguing all of this aggregate sentence together. What the trial court and the state on appeal have focused on is the prior criminal history and the fact that Mr. Jenkins was on probation. Again, that doesn't answer the question that we have raised here today and in our briefs. We are focused on whether the aggregate sentence was appropriate. And the only thing that the trial court said, and I reread the sentencing transcript this morning just to be sure, but the court just kept coming back to prior criminal history. He's getting this sentence because of his prior criminal history. He's getting this sentence because he couldn't comply with probation when he was a juvenile. That is what the trial court kept coming back to. But that is not the question under our case law after Bies and Pollard. That's not the question once you get past the statutory eligibility for consecutive sentencing. Essentially what the state, the way I interpret the state's argument is, if the trial court finds a statutory basis for consecutive sentencing, then any combination of consecutive sentences imposed by the trial court would have to be automatically affirmed by this court under the state's reasoning in its brief. And that's not what Bies and Pollard say. We still have an abuse of discretion standard. We still have the requirement that trial courts put their reasoning on the record so that this court will know that the trial court has thoughtfully considered whether the total aggregate sentence is what is justly deserved and is the least severe measure necessary. And here...
Yeah, he did have 19 cases, 19 convictions, right?
Yes, Your Honor. He pled guilty to 19 counts in 7 total cases.
So what is grossly disproportionate about the 16-year sentence for 19 cases, 19 convictions?
So most of those were Class A and B misdemeanors and Class D and E felonies. So for each individual count, for most of these counts, Mr. Jenkins was facing, as a range one offender, facing 1 to 2 years. But by stacking 6 of these cases, the only case that the trial court did not stack was one misdemeanor count. That was it, an 1129 sentence. All the other 6 cases, the trial court sentenced Mr. Jenkins to the maximum of 2 years in that 1 to 2 range, and then the maximum of 6 years for his one Class C felony, and then ran all 6 of those consecutive. So we have 5 cases of 2 years times 5 times 2 is 10 plus the 6 is how we got to the 16.
Let me ask you this. It was apparent when the judge was looking at restitution that he was mindful of how soon, as a standard offender, this defendant could be released from state custody. And to what extent, my question is not about restitution right now, but about the judge's assessment of what's a fair sentence. Is it fair or not that the judge looks at what the red date would be, deciding whether it's a fair sentence?
So anecdotally, Your Honor, I don't think I've ever had a client get released on their first red date. It just doesn't happen. TDOC is not releasing them when they first become eligible. So I think it is what we need to focus on here is this is, despite the state's argument to the contrary, this is a 16-year term of confinement. This is a 16-year prison sentence. And so while it is true that Mr. Jenkins would be eligible for release after serving the requisite portion of his sentence, there's no guarantee that he would be released at that time. And I think I can go ahead and skip to restitution because I think they're interrelated here. As Your Honor pointed out, there are 2 issues, several issues, but 2 I'll focus on with the restitution. Number 1 is that we argued the trial court did not consider Mr. Jenkins' ability to pay. The more I think about it, Your Honors, it's actually that the trial court did find that he was unable to pay and then imposed the restitution anyway, which is not consistent with the purposes and principles of sentencing. So to the extent that Mr. Jenkins' financial indigency was considered, I think the trial court made a clearly erroneous assessment of the proof when imposing restitution, despite telling the victims, you're probably never going to see a dime here. And then related to the prison sentence, that's why when we're talking about this total aggregate sentence that includes restitution, that's part of the punishment, we have to look at whether the purposes and principles of sentences are being served. And here, when you have a 20-year-old young man who's not held a steady job, who has no assets, who has no family or home life, a parent to speak of, and you send him to prison for 16 years, whatever part of that he may or may not actually serve, and the court is recognizing, the trial court was recognizing he's not going to be able to pay this. And the restitution judgment, he certainly does not have $200 a month while he's in prison. And then once he's released, I think the trial court was already recognizing once he's released, we can't expect that he's going to be able to make these payments. That's why the restitution portion, even on its own, should be reversed, Your Honors, because it simply is contrary to the way that this sentence is going to work.
So should it be reversed in the sense that he just shouldn't pay restitution, or should it be reversed, in your opinion, and sent back for maybe a more in-depth hearing on the issue? I mean, because you make your brief, it makes it appear, and I've not read the record, but your brief makes it appear that the trial judge just said it was a very short hearing. You can't pay, you don't have a job, but when you get out, you're going to start paying. I mean, we got to balance somehow between him having to pay some sort of restitution because that's part of a theft conviction and punishment versus, I understand your point, a 18-year-old kid who doesn't have a job, never had a job, and is going to be in prison for 16 years. So do we send it back for a more in-depth hearing, or does he just not have to pay restitution, or how do we balance these two things?
Sure. And I think we did request a remand, although I will say I think the record is complete if the court wanted to do a de novo review. There is enough here for the court to do that de novo review. But I think the case law indicates that the court prefers to remand. So that's why we argued that. But if there is a remand here, what we're asking the court to do is tell the trial court, do more, do a better job here. And it's not just, is there any amount of restitution to be paid? It's together with the restitution and the prison sentence. Does this make sense, what we've done here? And I think that if there is some restitution to be paid after the trial court accurately considers the financial information that was in the record, then the question becomes, maybe he shouldn't have a 16-year prison sentence if we want him to pay some of this back. And that's where this aggregation comes in. If, that minimum that the court could have imposed was 3 years. Mr. Jenkins has never been to prison before. It's his first time going to prison. I understand that the court thought the crimes were serious and that it had to protect the community. But that just goes to confinement itself. Just like being on probation and having a criminal history just go to eligibility for consecutive sentencing. Beyond eligibility and beyond, he has to pay some restitution, there has to be some assessment of how does this sentence work together so that Mr. Jenkins is appropriately punished for what he has done, but the victims also have a chance at getting restitution, and also the interests of the public are served as well. I think that's what's missing from this record. This trial court did not take that into consideration.
And then I want to go back to a statement you made kind of a bit ago about how Vice and its progeny don't just give kind of a carte blanche, judge, do whatever you want. But at the same time, as a judge on this court has said a couple of times when I've sat with them, it does kind of tie our hands on how to review sentencing, because as long as, for lack of a better way of saying it, as long as the judge says the magic words and kind of goes down the list, it takes our review out of it as long as we're checked those boxes. And the perfect example would be, I can misapply 2 or 3 enhancement factors and still have a presumption of reasonableness and correctness. So how do we, if he checks the boxes, so to speak, and I don't mean to be so flippant about it, but if he checks the boxes and says the magic words, where are we supposed to say 16 years is too long?
So two things to that, Your Honor. Number one, I don't think that the record reflects that the trial court here really checked the boxes for consecutive sentencing. Consecutive sentencing is something more than a within range sentence. I understand within range sentences and misapplying an enhancement factor to me, that's very different than, do I stack 6 different sentences all consecutively to go from 3 years to 16 years? To me, that's a big difference from a within range sentence. So I don't think that the boxes were checked there. The second point to that, Your Honor, though, is more substantively, is the reason that we don't know that 16 is the right number is because the trial court did not show that work. The trial court just kept coming back to prior criminal history. He was on probation. That's not enough. That just gets you to the trial court has the discretion to impose those consecutive sentences, but it does not support why 16 years was the least severe measure necessary, especially when coupled with this restitution that now the trial court acknowledges, well, he's probably not going to be able to pay that now that I'm sending him to this lengthy term of imprisonment.
He didn't exactly say he's probably not going to be able to pay it. He said to the victims, you may never see it. That's 2 different things.
I think the context of it, Your Honor, was that the trial court was recognizing he's got a long sentence to serve. He might get out. His red date is after 4.8 years. He might get out then. Maybe he'll do the right thing and make these payments. But victims, don't hold your breath. That's what he told the victims. Don't hold your breath.
That's what I understood him to be saying, and that he may choose not to get a job and not to pay it. He may choose to ignore the restitution order.
And if that's the case, Your Honor, then the victims have the mechanism of the conversion to a civil judgment later down the road. So it's not that it's a completely empty promise there. I think the problem with it in this case is how practically it might work in conjunction with the lengthy prison term. And Judge Dyer, I just want to make one more point in response to your question about how this works, is that we're not just talking about this isn't just a vacuum, right? As a practical matter, what are we doing with sentences, and what are trial courts doing with sentences to make sure that the purposes and principles are served? And this court, again, even after Bias and Pollard, there's still an abuse of discretion, right? There's still the possibility that the trial court abuses its discretion. This court does not have to turn a blind eye if the trial court makes a clearly erroneous assessment of the proof or reaches an illogical conclusion. I think that's really what we're talking about here is 16 years coupled with restitution that he's probably not going to be able to pay is not a logical conclusion, not just for Mr. Jenkins, but even for the victims of the theft who would like to see some of the money repaid, and that's essentially been taken away from them.
Reserve time now, Ms. Wingarter.
Thank you, Your Honor.
Your Honors, good afternoon. Jonathan Wardle for the state of Tennessee. I think I'll start with the consecutive issue. And I recognize that counsel wants to lump the consecutive and the restitution together as one kind of overall sentence, and I understand that. But they are two separate parts of the sentence. And so I'm going to address each separately. And if Your Honors have questions about how they relate together, I'll be glad to handle those.
Are you going to talk about consecutive issue that adds up to 16, or are you going to talk about consecutive issue to the Rutherford County sentence?
16 years, Your Honor. 16 years.
16, okay.
Unless you would like to question me on that.
Well, I just wonder, we've got a senator out of Rutherford County, a community correction sentence, which we talked about. The Rutherford County judge, once he gets back, because apparently there was an outstanding violation on this defendant when he was caught for the Rutherford County cases. There's a hold on him. He's got to go back to Rutherford County to face that music. And the Rutherford County judge could very well increase that sentence. Correct?
Your Honor, I cannot answer that. I cannot answer that because we do not have anything in the record about what was there. I suppose
he was
theoretically
on corrections, though. Correct. He was on a correction sentence.
I believe that's correct. And in theory, yes, it could be increased. In theory, it could also be decreased. The judge could say, you know what, I'm going to put you in confinement, but instead of 5 years, let's do 3. Right? The point is, we don't know on this record what happened in Rutherford County. And we don't have enough before us to really make a sophisticated guess as to what was going to happen.
Okay, talk about the 16 then, if that's what you want to talk
about. Thank you, Your Honor. And I will, I will say that finally on that one point, the court doesn't have to look at the prior case and say, oh, well, because you had that prior case, I'm going to let you slide on this case and impose a lesser sentence. Now, I'd kind of be saying, well, because you did a bad job before, we're going to give you, on a grace period. Yeah, we'll give you another grace period. And I don't think that's what the law is. Right. So here on the 16 years, I think Judge Witt hit it very nicely. This is 19 separate crimes, 16 after merger, 9 felony convictions, a total of 16 years. That's not unreasonable. I just got a notice. Well, I'll figure out if that works. My earphones may die, and if they do, we'll deal with that in a moment. I'm sorry about that. The defendant wants to kind of reframe Bias and Pollard. I like this eligible for consecutive sentences framing. That's not how I read Bias and Pollard. I don't think the defendant is seeking eligibility for consecutive sentences. What we have is a statute that says the court has discretion to impose consecutive sentences if it finds any one of 7 things. Here, the trial court found 2. And I have yet to hear a defendant say that that was an improper finding. Those 2 findings were supported by the record. At that point, we don't have an abuse of discretion. It followed the law, it understood the law, it articulated its findings, and there's evidence in the record to support the findings. I think that's where this court then on review says, well, we've looked at those factors, it's not an abuse of discretion at that point. And I think that's clear. I want to address really quickly the Biggs case, because that's cited heavily in the defendant's brief. The Biggs case is interesting, but I looked up every case, every opinion from this court that has cited Biggs since it came out. There are 7 of them, right? And it's interesting because 5 of those cases distinguished Biggs and affirmed consecutive sentencing. One of those cases distinguished Biggs to affirm sentencing confinement. The consecutive sentencing wasn't an issue. It was whether it could be in confinement as opposed to alternative sentence. And the last case, the defendant argued that Bison Cottle effectively eliminate any meaningful review of a trial court sentencing decision, and then looked at the Biggs dissent to say, that's wrong. And this court said it lacks the judicial power to overturn a previous ruling of the Supreme Court. The point I'm trying to make is that Biggs is it exists for very extreme situations. This court can look at, this is just outrageous. But that's not what we have here. We have a 16-year sentence for a gentleman who can't seem to stop committing crimes. And I would point out in this case, not only did he commit some thefts and some burglaries, but these were extremely vulnerable populations, right? A senior care center had the tires stolen from the van, and it impacted operations for multiple weeks. A woman with a high-risk pregnancy, people dropping their children off at daycare centers, right? These are vulnerable populations that he's targeting, right? And they suffer significantly, right? So I don't think the trial court was crazy to impose a 16-year sentence for 16 crimes after merger. Unless there are questions on the consecutive sentencing issue. All right, I'll turn to the restitution issue. And what I'd like to do for restitution is just walk through the statute. I think that's the best way to frame this and to address this. So Judge Dyer hit on the issue that the trial court by statute is required to impose some form of restitution for theft convictions. That's section 40-20-116, subsection A.
Mr. Wardle, what's the point of imposing restitution if the trial judge in turn makes the comment to some effect, he's probably never going to pay this? What's the point?
Well, so that is honestly something I've wrestled with throughout this, and where I've gotten to on this is the statutory scheme. First of all, requires a restitution order, and secondly, the trial court in this case simply didn't say he cannot pay. I think Judge Witt was right there, but he acknowledged the court acknowledged the practicalities that this defendant might not pay. If this court wants to change that, it needs to go to the statutory scheme. That's the legislature that imposed the requirement for restitution when it's imposed.
Well, I don't want to change the statutory scheme. That's not my point. But my point is, if I'm the trial judge and I'm trying to both punish the defendant and also do what the statute requires me to do, is make the victims as whole as I possibly can within reason, what's the point of maxing out basically to about $10,000 or whatever when I know that's not going to happen? Why not do a little more work, so to speak, at the trial court level and figure out, hey, the number really shouldn't be $200 a month, but using his same rationale, hey, he could get out in 4 years. He's a young man. What does, $75 a month or $100 a month? It still may never see a penny. I understand that. But to go ahead and give full restitution and at the same time acknowledge you're probably not going to see any of this seems to defeat the purpose of both punishing the defendant and trying to make the victims somewhat whole.
Well, I can answer Your Honor's hypothetical, but I want to make it very clear that I don't think the trial court found you will never see any of this. In fact, I can quote for the record here, right? He does say, don't hold your breath. You're probably not going to get restitution. But the very next thing he says is, if you do, it's going to be somewhere later down the road. And then he goes on and continues to talk about that, right? I don't think the court is saying you're never going to see anything. I don't think the facts we have here is the court finding he cannot pay, he'll never pay. The court's recognizing the practical reality that it's going to be a long time and it may be difficult for him to pay. But to address your hypothetical, the point of imposing restitution, at least according to the legislature, as I understand it, is one, to punish, it's part of the punishment for theft, and two, it is to try to help the victims out. And as counsel pointed out, at the expiration of the sentence, the victims can go through a process to get the restitution converted to a civil judgment, right? And I'll get back to that, but that's something that is in the statute. Again, you could say the same thing. Why go to court in civil case against a penniless, creditor, or rather debtor, right? But people do that. The law is what the law is. Getting back to the statutory scheme, once the court decides to impose restitution, and here it didn't have an option. It had to impose some form of restitution. And I guess I would point out here that defense counsel acknowledged that there should be some restitution, said it flat out in the record. Even on one particular case, I think it was the Belisar case, said, yeah, we know he's got to repay that. All right, so defense counsel knew there's going to be restitution, acknowledged there's going to be restitution. All right, what the court does is first it must, the pre-sentence report must contain documentation regarding the victim's pecuniary loss. That's in section 40-35-304, subsection B. And everything else I'm going to talk about here is from section 40-35-304. It's a comprehensive scheme, and the trial court did everything on it here. So first, there was documentation about the victim's pecuniary loss. It was in the pre-sentence report. It was also in the victim impact statements. And then, of course, you had some of the victims testify. Right? So that was there. Check. Right? There's nothing in there that says the court has to lessen the amount just because, the defendant, is poor. It just says there's got to be documentation about the loss. It's there. Number two, the trial court must set the amount of restitution and the time of payment at the sentencing hearing, which it did. That's in subsection C. If there are multiple victims, the court can or must determine the pecuniary loss of each victim and order amount of restitution to each victim. Again, check. The court did that. That's in subsection G sub 3. All right. Then the court is allowed to can require payment in installments. All right. That's in subsection C. All right. The court is not required to impose a specific end date, other than the payment schedule cannot extend beyond the sentence's expiration date. So what I'm trying to say here is the court doesn't have to do some sort of civil judgment here. All right. It just says it can't extend beyond the expiration date of the sentence. And that's section 40-35-304, subsection G. Beyond the sentence's expiration date. 2. Can you all hear me?
Yep.
Okay. Otherwise, besides the fact that it ends at the expiration date, the defendant remains, quote, responsible for payment of the restitution until the expiration of the sentence imposed by the court. So again, we're just looking at this is part of the sentence. You have until the sentence is done to pay. In determining the amount and method of payment, the trial court shall consider the financial resources and future ability of the defendant to pay or perform. Check. And I want to highlight this. Again, the court shall consider the financial resources and the future ability. It doesn't say that the court has to find that the defendant has any specific ability to pay any specific amount. It doesn't have to find what the defendant can pay. It just has to consider it. And it's clear from the record the trial court did consider that. So check. Finally, the defendant can later request an adjustment to the payment schedule if the circumstances change. So when he gets out of jail, if he can't find a job, he can come to the court and say, look, I've been trying to find a job. I can't. Can we lower it? And he can do that. All right. So just walking through the statute, trial court checks off every single box. Right? I want to point out a few other things, right? The statute does not require the trial court to make a finding regarding a specific amount a defendant can pay towards restitution. I already mentioned that, right? The reason I point that out is there are cases where you do. Those are child support cases and the like. If we wanted to make the trial court come up with a specific finding about exactly how much a defendant can pay, you would have to have some sort of civil discovery type thing going on. You'd have to be able to subpoena his financial records, his employment history, and it would really become like a child support case. And that's not what the criminal courts are supposed to be doing here. All you do is consider his ability to pay. Besides, it would be a waste of time because a lot of these defendants will be incarcerated until for the foreseeable future. And here I want to make a point. A shorter sentence is not going to make it easier to pay restitution. If anything, it will make it harder. Again, he has until the expiration of his sentence. So if you give him a shorter sentence, he's going to have less time to pay off restitution. Right? That's just a matter of simple math. I'm not saying that you should extend a sentence so that he has a longer time to pay off a sentence, but you shouldn't reduce a sentence thinking, oh, that'll make restitution easier. It's exactly the opposite. I already mentioned this is on page 66 and 67 of the sentencing hearing transcript, which is volume 4, where the court notes the difficulties Mr. Jenkins may have making payments, but he absolutely considered his ability to pay. And the trial court, the way I read pages 65 through 67, the way I read that is the trial court anticipates that Mr. Jenkins will begin to pay when he's released on parole, right? And that's because he mentions Mr. Jenkins will be considered for some type of parole after he serves 4.8 years. And then very soon after that, right, within a paragraph, the court is talking about, you may not see payment for a long time type of thing, right? So the court's considering all the stuff it's required to consider here. One thing I want to point out, and I'm pointing this out because I haven't heard questions on it, so maybe it wasn't confusing to you all, but I was confused about this. And I dug into the statutes, into the case law. You don't have to put down in the order when payments will start and when exactly they'll end. You don't impose post-judgment interest. You don't do any of that sort of stuff. It's not like a civil case, right? The Sanders case is a good example. And it's cited, I think, in both briefs. I know it's cited in my brief. The Sanders case is a good example where the court, or rather the defendant argued, hey, I can only pay restitution if I get an alternative sentence, right? And the law is you can have incarceration and restitution. And the court affirmed, noting that the trial court had found the defendant would likely be released within 3 years, giving him 7 years of community release to pay restitution, right? What that means is, again, you can be incarcerated and then begin to pay once you're released. And that's totally within the restitution scheme. This is what the statute allows for, right? I think the last point I want to make here is that Mr. Jenkins can pay all of this restitution off with plenty of time, even if he's not let out at 4.8 years. Right? This is going to take 4 years and 1 month to pay off if he pays $200 a month. $200 a month is not an egregious amount to pay when you robbed 7 people of $10,000. $200 a month is actually a pretty good order. It'll take just over 4 years. He's got a 16-year sentence. So if he gets out at 5 years, he's got 11 years to pay it off. But he could get out at almost 12 years and still pay it off if he abides. And the very last point that relates to that is he's not unemployable. In fact, he had a job. I've heard comments that, he was homeless and jobless. It's not true. I don't know if he was homeless or not, but there's nothing in the record other than counsel's statement that, maybe he didn't have a permanent place to live. But that's not proof. It's counsel's statement. And it was a maybe. What we do have in the record is that he held a job in 2018 from February to April. I assume April is when he was arrested in Rutherford County, because when he's released from Rutherford County, when he pleads guilty in July, he gets another job. He has a job from July to October, and he's doing fine. Then he moves to Jackson. When he goes to Jackson, he gets a job, and he has that job from October to December. What happens, though, is in October, he stops reporting to probation. At the end of November, he starts committing crimes again. And then, by April, he's arrested and he's in jail again. Right? The point is, this is a gentleman who has a history of showing that he can get a job. Right? But I think on these facts, the trial court did not do anything egregious. It certainly didn't abuse its discretion in looking at the statute, looking at the scheme and saying, you know what? I'm considering his ability to pay. But he robbed 7 people. They're entitled to restitution. I'm going to order it. He's got a long sentence, but it's not an unreasonably long sentence for the number of crimes he committed and his criminal history. So I'm going to put in a slow pay order, essentially. Unless there are further questions, we would ask that this court affirm. Thank you.
All right, rebuttal.
Thank you, Your Honor. May it please the court. Very briefly, before I get into a few points I'd like to make, I find it interesting that the state wants to emphasize counsel's statement as being irrelevant when related to Mr. Jenkins' homelessness status, but then rely on counsel's statements when arguing that restitution is appropriate. So I just want to point that out to the court. Either counsel's statements mean something or they don't. To the first point I'd like to make is the state wants to separate the restitution and the sentence. That's not how this works. Restitution is part of the punishment. It is part of the sentence. And the question for consecutive sentencing is the total aggregate sentence reasonably related to the severity and justly deserved and the least severe measure necessary? This court can look at them separately, but it also has to look at them together for the total aggregate sentence because restitution is part of the sentence. I want to make a point about Pollard as well. In Pollard, the court said the governing statute provides that the court may, and the word may is emphasized in Pollard, may order sentences to run consecutively if the court finds that the defendant falls into one of those categories. The may is what indicates that the statute for consecutive sentencing is simply the first starting point. Whether the court actually does impose consecutive sentencing in some manner is discretionary. And in making that discretionary decision, the trial court is supposed to consider what is the least severe measure necessary and what is justly deserved. That's in Pollard itself. There's actually another case from this court after Pollard that laid it out pretty clearly. The court must still, when imposing consecutive sentencing, the court must still consider the general sentencing principles that each sentence shall be justly deserved, no greater than that deserved for the offenses, and the least severe measure necessary. Those are the things that we are missing in this record. All we have are statutory factors that the trial court relied on, and that is not enough. For the restitution, I heard the state to say several things, and I think about what the court has to do for restitution. I think it missed one. This court has said what all that the trial court has to do is simply determine what the defendant can reasonably pay. What is he reasonably able to pay? That is in this court's restitution case law. That is what this trial court did not do. And finally, on the distinction between civil cases, and I want to touch briefly on the Sanders case. We cited Sanders in our reply brief just to point out why it does not apply, though the state has relied upon it. In Sanders, that defendant had $47,000 in assets, and he agreed to pay a range of restitution that the trial court then set. And we explained in our reply brief why that is so different from Mr. Jenkins as an indigent, again, formerly homeless, as is reflected by counsel's statements. His mother died when he was 7. He was in and out of foster care in juvenile detention facilities. He was not anything like the defendant in Sanders. And because we don't do these heightened civil case type reviews in criminal cases, the bare minimum that the trial court has to do is determine what is this defendant reasonably able to pay. That is what we are missing here. And we ask this court to reverse.
All right. Thank you. Court appreciates the arguments you brought today, and this concludes the arguments in this case.
This Honorable Court of Tennessee is now in recess.